Hello, everyone, and welcome to the 37th Annual Charles W. Froessel Moot Court Competition. We're proud of each and every person in this room. You did a fantastic job. I just wanted to start off by, I'm Catherine Brunetto, and this is Ariel Cabral. We are the co-chairs of this competition. I'm sure you've seen us around. We just wanted to extend special thanks to the 2013-2014 Moot Court Association and Executive Board for their enormous contributions to this year's competition. We pay special tribute to Ilona Kukai and Alex Noble for this fantastic fact pattern that has rattled your brains for the past 5 days. We extend special thanks to Professor Nadine Strassen for her support in also developing this year's fact pattern. And we would especially like to thank Dean Kroll for his unyielding support of our association. We also greatly appreciate the dedication of our executive editors, Garrett Baldwin and Michael Risciuto. Our Public Relations Chair and Media Chair, Raymond Quiles. Moot Court Chair, Mark O'Neill. And our Vice Chair, Ms. Catherine Baxter. And also a special thanks to Stephen Cunningham, our staff administrator, and for his extensive planning and coordinating efforts throughout the entire competition. And of course, our faculty advisor, Susan Abraham. This wouldn't have been possible without her support and guidance. And finally, thank you to all of our participants this year.
We'd also like to thank Dean Archer, who is attending today, and she will be attending the final round dinner. Thank you so much for agreeing to attend. Now, also, in addition to thanking everyone here, we'd like to thank the final round panel for agreeing to participate. Without them, there would be no Froessel final round. Let me just tell you guys a little bit about the final round panel. The first judge that we have today is the Honorable Susan J. Abraham. Susan Abraham is a professor of law at New York Law School, where she teaches evidence, advanced appellate advocacy, and principles of legal analysis. Professor Abraham also serves as the New York Law School Moot Court faculty advisor, as Catherine stated before. She has represented indigent criminal defendants in New York and New Jersey at both the trial and appellate level, and has also represented clients in disability discrimination, employment, criminal, pension, and other matters. Susan Abraham earned her BA in English from Oberlin College in 1977 and her JD from Rutgers Law School in 1983. In addition, she received her MFA in creative writing from Warren Wilson College in 1991. The second judge we have on the panel today is the Honorable Bridget Amiri. Bridget Amiri is a senior staff attorney with the American Civil Liberties Union Reproductive Freedom Project, where she's worked since 2005. She's also an adjunct professor of law at New York Law School, where she teaches a reproductive rights seminar. In addition, she serves on the board of directors at Law Students for Reproductive Justice. Amiri has spearheaded several initiatives, including an effort to fight abstinence-only until marriage programs and several high-profile challenges to laws threatening to ban or restrict access to abortions. Prior to working at the ACLU, Amiri worked as a staff attorney with the South Brooklyn Legal Services Foreclosure Prevention Project. Amiri earned her BA from DePaul University in 1996 and her JD from Northeastern University School of Law in 1999. The third justice on the panel today will be the Honorable Justice Joseph E. Arenas. The Honorable Justice Joseph E. Arenas was appointed by former President George Herbert Walker Bush as a federal judge for the United States District Court for the District of New Jersey on November 14, 1991, and was confirmed by the Senate on April 8, 1992. Prior to serving as a federal judge, he began his career in private practice working at McCarter & English from 1966 to 1992. Judge Arenas has also served as an adjunct professor at Rutgers University since 1985. A native of Newark, New Jersey, Judge Arenas holds a BA from Princeton University and a JD from Harvard Law School, from which he graduated cum laude. He assumed senior status on July 1st, 2002. The fourth judge who is serving as our Chief Justice today will be the Honorable D. Brooks Smith. The Honorable D. Brooks Smith is a judge on the United States Court of Appeals for the Third Circuit. Judge Smith was nominated to the Third Circuit by President George W. Bush on September 10, 2001, and confirmed by the Senate on July 31, 2002. Prior to his appointment to the Third Circuit, Judge Smith served as the Chief Judge on the United States District Court for the Western District of Pennsylvania, where he was first appointed in 1988 by President Ronald Reagan. Judge Smith received a BA in government from Franklin and Marshall College and a JD from Penn State Dickinson School of Law. The fifth and final judge on the panel today will be the Honorable Fabiola Soto. The Honorable Fabiola Soto is an acting judge on the New York State Court of Claims appointed by former New York State Governor George Pataki in 2006. Prior to serving on the Court of Claims, Judge Soto served 2 terms as a New York County Supreme Court Justice from 2002 to 2006 and a civil court judge in New York City from 1994 to 2006. She is a Reginald Heber Smith Fellow at Bronx Legal Services and has the distinction of being the first judge of Dominican descent to sit on any court in the state of New York. Judge Soto earned her BS from City University of New York and a JD from New York Law School in 1978. Let's have a round of applause for our judges.
The Moot Court Association and the entire New York Law School community proudly honor our distinguished alumnus, Charles W. Froessel, by hosting this competition in his honor. Charles W. Froessel received both a Bachelor of Law and a Master's of Law degree from New York Law School in 1913. He was an honored leader in his profession, serving the state of New York with distinction. His roles in public service included Sheriff of Queens County, Assistant District Attorney in Queens County, Special Assistant to the United States Attorney General, Justice of the City Court of the City of New York, and Associate Judge of the New York Court of Appeals. Charles W. Froessel was also the Chairman of the Judicial Section of the New York Bar Association and the President of the Queens County Bar Association. Devoted to legal education and the law, he served with distinction as a professor and a member of the Board of Trustees of New York Law School. We pay tribute to Mr. Froessel today. Now we are going to call up Mr. Alex Noble and Ms. Salona Kukai, the editors of this fact pattern, to familiarize you with the facts of the case that you'll be hearing today.
Hello, everyone. The case you will hear argued today has to do with the Family Solutions Clinic, which is a reproductive health care facility located in Franzia, a small city in the state of Froessel. Family Solutions provides a variety of family planning services, including abortion. Dr. Joam Jaffrey is the founder and head physician of Family Solutions, and due at least in part to his efforts, Family Solutions is the only remaining facility in the state of Froessel that performs abortions, since 2 other facilities closed in 2010. In July 2012, 2 leaders of the local Eastwood Guardians Church, Reverend Mark Baxter and Kate O'Neill Baxter, initiated a campaign to oppose what they regarded as Family Solutions' immoral medical practices. On July 1st, 2012, over 50 members of the Eastwood Guardians Church descended on the Family Solutions Clinic, congregating on sidewalks and public parking lots adjacent to the facility and displaying signs proclaiming the messages "Choose life" and "Kill the rapist, not the baby," and shouting epithets such as "baby killer" and "sinner" at the men and women entering and exiting the building. An hour into the protest, officers from the Franzia Police Department received a call from Dr. Jaffrey after a violent confrontation broke out between the Eastwood Guardians and several students from nearby Zachary Ziegler High School. A full-scale melee broke out, leaving several students severely injured. Local news outlets covering the event aired footage of Byron Ullman, a 4-year-old child who was knocked unconscious in the parking lot when fighting demonstrators fell on top of him. On July 4th, the Eastwood Guardians issued a press release in which they expressed their regret over the violence and vowed to keep their advocacy peaceful. Since then, the Guardians have abandoned mass demonstrations in favor of a new strategy focused directly on patients and staff. On most weekdays during the clinic's operating hours, the Guardians stationed 2 demonstrators outside the facility, while one member patrolled the parking lot to intercept incoming vehicles and distribute pro-life literature to occupants. The second demonstrator stands in front of the facility's entrance, displaying signs to express condemnation of abortion and plead with entrants to reconsider their decision to seek one. The protests brought about a sharp decline in patient attendance. For the first time in the history of the clinic, the head doctor, Jaffrey, received calls from patients requesting in-home treatment, counseling, and even abortions. Most callers reported feeling unsafe at the clinic due to the presence of the Guardians. Most visits to the facility passed without incident, but the FPD was called several times to break up altercations between escorts brought by patients of the facility and demonstrators who were approaching them. On 2 occasions, demonstrators obstructed the path of cars turning into the facility parking lot. Both occasions resulted in rear-end collisions that injured drivers and temporarily shut down the main street to the facility. At the same time, there were also protests outside non-reproductive health care facilities in Franzia. Most notably, blood banks run by the Green Star Clinic have resulted in liability that forced the organization to scale back their operations. By early December, the Froessel legislature drafted and passed the Froessel Medical Privacy Act, which became effective on December 15th. Section 3.14 of the Act imposes civil liability on any person who knowingly approaches within a 12-foot bubble of another person for the purpose of engaging them in oral or visual protest, education, or counseling. This floating bubble is created around any person within a 50-foot radius of the entrance to a reproductive health care facility. In a legislative report, the bill's sponsors explained, "We recognize that Froessel citizens their access to medical care must be protected, and thus find it necessary to prohibit one person from interfering with another's access to healthcare facilities." On April 1st, the legislature held a hearing to assess the impact of the new statute. The hearing revealed that the number of men and women attending Family Solutions had returned to previous levels. The clinic's resurgence was attributed in part to a new volunteer program created pursuant to an exception in the statute for agents and employees. The exception allows agents and employees of a facility to approach within 12 feet of those entering or exiting the facility without first having to obtain their consent. Clinic volunteers can thus help patients access the facility without fear of violating the statute. Family Solutions instructed their volunteers to approach patients by first introducing themselves and then declaring their intention to help the patient enter the clinic. On December 15, 2012, Reverend Baxter arrived at the sidewalk outside Family Solutions at 2:15. Approximately 30 minutes later, Catherine Cabral, a marketing consultant whom Family Solutions had hired to improve their public image, drove into the Family Solutions parking lot and pulled into a space 30 feet from the entrance. Reverend Baxter rushed toward the driver's side of her car to confront Cabral. While Cabral was stepping out of her vehicle, Reverend Baxter approached within 3 feet of her without her consent. A Zachary Ziegler High School student then took out her smartphone and began recording the events that followed. The video shows Reverend Baxter chasing after Cabral as she walks briskly toward the clinic door, shouting a variety of epithets, Baxter said, including murderer and prostitute, while he held up a small poster captioned with the phrase, "Choose life." The footage ends with a police officer citing Reverend Baxter for violating Section 3.14a of the statute, the floating bubble provision, and after Reverend Baxter received a civil penalty in the amount of $250, he filed this facial and as-applied First Amendment challenge to the statute in the United States District Court for the District of Froessel on January 12, 2013.
The second issue on cert involves the Mendic Times, which is Froessel's most popular online newspaper. The Times website allows users to generate profiles to comment on articles, and even submit original content. The publication of user content is subject to approval by website administrators. One of the website's most viewed stories reported on a burglary that occurred at Family Solutions on April 15, 2013. Although the intruders left the clinic's expensive equipment untouched, several items were stolen from Dr. Jaffrey's office, including patient records and Dr. Jaffrey's laptop, which contained video files of all counseling interviews he conducted with patients at the clinic. The following day, the website user, Anonymous, posted a video showing Katerina Baxter, the daughter of Reverend Baxter and Kate O'Neill Baxter, visibly distraught, speaking with Dr. Jaffrey in his office about the methods the clinic uses to carry out abortions. When Dr. Jaffrey informs her that state law requires minors to provide proof of one parent's consent to have the procedure performed, Katerina hands a document to Dr. Jaffrey. The video went viral and gained statewide attention. The Froessel Medical Review Board subsequently conducted an investigation to determine whether Dr. Jaffrey unlawfully performed an abortion on a minor without parental consent. The investigation revealed that Dr. Jaffrey performed the procedure and had in fact obtained consent from Katerina's mother, Kate O'Neill Baxter. News of Katerina's abortion shocked the Baxter's congregation. Senior Eastwood Guardian members forced both parents to abdicate their leadership positions. As the video circulated, Katerina received scores of threatening letters and phone calls, which ultimately caused the Baxters to relocate to a neighboring town. Reverend Baxter sent a letter to Ockert warning her that he would take action pursuant to FMPA Section 3.15 if her newspaper ever printed anything about this incident again. Ockert, fearing liability under this statute, which provides a civil cause of action against any person who intentionally discloses the contents of a recorded communication with the knowledge that the recording was unlawfully obtained, filed an action in United States District Court for the District of Froessel. The suit challenges the constitutionality of Section 3.15 and seeks a declaratory judgment that it is unconstitutional as applied to Ockert. Pursuant to the Federal Rule of Civil Procedure 42A, the District Court consolidated Ockert's constitutional challenge to Section 3.15 with Reverend Baxter's challenge to Section 3.14 of the FMPA in light of the substantial overlap of witnesses and facts. Thank you for listening, and we hope that you have fun. Yeah.
All right, without any further ado, we'd like to introduce our four finalists who blew us all away, and they will be arguing now in a couple of minutes. The first finalist is Leopoldo Guerra. He will be arguing Petitioner 1 for the state of Froessel. Our second finalist is Aruna Chitiapa. She will be arguing Petitioner 2, Mark Baxter. Our third finalist is Naveed Froessel.
I'm sorry. Aruna Chapata will be arguing Respondent 1, Mark Baxter. Okay. Sorry, Camelia Ockert.
Camelia Ockert.
Apologies.
Sorry.
I'm
going to have to fire whoever wrote this script. Okay, so Naveed Froessel will be arguing Mark Baxter.
Yes.
Okay, so Naveed Froessel is our third finalist. He will be arguing Respondent 1, Mark Baxter. And our fourth and final finalist is Michael Forsetti. He will be arguing Respondent 2, the state of Froessel. Congratulations, guys. United States are admonished to draw near and give their attention to the court now sitting. God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Abraham, Soto, Chief Justice Smith, Justice Arenas, and Justice Amiri presiding.
Please be seated.
First case on the calendar, the 22nd day of the month of September 2013, is State of Froessel petitioners against Mark Baxter, respondent, and Camilla Ocker, petitioners against State of Froessel, respondent.
Counsel ready to proceed?
Good morning, Chief Justice, Your Honors. My name is Leopoldo Guerra, and I represent the State of Froessel, the petitioner in this action. At this moment, the State of Froessel would like to request 1 minute for rebuttal.
Granted.
Thank you, Your Honor. The State of Froessel requests this court to reverse the 13th Circuit's decision, which improperly held that Section 314, subsection A, is unconstitutional. This case is about protecting women's rights access to healthcare facilities.
You know, what might be helpful to the panel, because we're all familiar with the facts, would be for you to explain to us, given the absence of any kind of map or schematic in the record, just how this 50-foot zone, as well as the 12-foot floating bubble, actually work on the ground.
Sure, Your Honor. So the statute says that if you're within 50 feet of a reproductive healthcare facility, you cannot approach another person within 12 feet without the other person's consent to engage in a communication that could be interpreted as educating, counseling, or protesting.
Is that within 15 feet of the door of the facility?
Yes, Your Honor.
And how many doors are there? Could you explain a little about the structure, the parking lot, where public sidewalks start? Just give us kind of the, if we were to be looking at a map of the facility, what we would
Sure,
be
Your
looking
Honor.
at.
The clinic has 4 entrances, and the space between the entrance and the parking lot is 40 feet, and then the sidewalk is 10 feet. The state requests the court to acknowledge that the proper standard review in this case is under the intermediate scrutiny level, because the statute is a content-neutral restriction on time, place, and manner. Nowhere in the text it says that it prohibits certain kinds of speeches. It just says that it prohibits all speeches that are in the...
Of course, that's what it says, because the statute wouldn't want to be treated as a content-based restriction. But doesn't the fact that it exempts an agent of the clinic make it content-based? Because an agent can speak, but an anti-abortion protester can't?
Your Honor, the employee exception is not made on the content of the speech. It's made on the affiliation of the people with the clinic.
Excuse me.
Why is that different from content? If you're affiliated with the clinic, you're pro-abortion. If you're not and you're anti-abortion, you can't speak. Why isn't that a content-based restriction?
Because, Your Honor, the employees of the clinic have to be acting within the scope of their employment, and their only function is to bring people back and forth from the entrance to the clinic to the street. Furthermore, the employee exception, although has not been decided by this case, there's a national consensus among the different circuits that an employee exception does not render a content-neutral statute content-based.
Well, we don't care about what the circuits say. We're the Supreme Court. We make the rules. And let's consider something other than just the employee exception. That's one factor. But shouldn't this court be looking at the statute as a whole?
Absolutely, Your
All
Honor.
right, in looking at the statute as a whole, we're looking not only at the employee exception, but how about the fact that this statute targets not all health care facilities, but all reproductive health care facilities? Doesn't that tell you it is specifically targeted at speech that is about abortion, and more particularly, speech of anti-abortion protesters?
Chief Justice, although there's a case called Hill versus Colorado decided in 2000, and although that statute was targeted at all healthcare facilities, Justice Stevens, writing for the majority, said that even if it was targeted exactly, especially as a reproductive healthcare facility, the statute will still be content neutral. Furthermore, this case has held in different cases.
How does Hill help you? You think that Stevens' language suggests that this court would uphold a statute of this kind that targeted only facilities having to do with reproductive health matters?
Well, Your Honor, there's case history decided by this case that have, for example, in Madsen versus Women's Health Center, that injunction was targeted specifically at reproductive health care facilities. Nevertheless, the reasons for striking down that injunction were not the fact that it was directly targeted at the reproductive health care facility.
Looking at the statute as a whole and in line with Hill, what about the fact that the bubble in this statute is 12 feet? It was only 8 feet in Hill, wasn't it?
Yes, Your Honor. Unlike Hill, the bubble provision here is 12 feet. Nevertheless, the ratio in Hill, where the bubble provision activated, was 100 feet radius. Here is 50 feet. Furthermore,
But I think that's apples and oranges, right? I mean, how far the fixed buffer isn't necessarily indicative of whether the floating bubble is constitutional or not, depending upon how far you have to be within the bubble. I think that they're two different things. Do you see them as related?
I believe that the state believes, that a 12-feet restriction is not bordering more speech than necessary. The state believes that at 12 feet, a person can still engage in a normal conversation.
You would concede, wouldn't you, that this bubble and the extent of this bubble forecloses any opportunity on the part of someone seeking to argue or protest or engage in educational activity or those functions that are set forth in the statute from actually leafleting? Absolutely prohibits that, doesn't it?
Respectfully, Your Honor, I would not concede to that because this statute has some safeguards. For example, it has your stand your ground provision. Under this statute, a person that has that wants to protest or engage in educational or counseling type of speech can stand on his ground, set chop, and people can approach him and he can still deliver his message.
What about?
We're 12 feet apart, you and I. We're having a conversation, aren't we?
Yes, Your Honor.
With microphones.
Even without microphones, we could talk to each other, can't we?
Yes.
That's a softball for you.
But doesn't Mr. Baxter make the point that the stand your ground provision really, in the context of this particular clinic, means nothing because there are multiple entrances to the clinic where the women could basically escape or evade his position outside?
Yes, Your Honor, but I think we should defer to Congress in deciding that, first of all, that the 12-foot bubble is reasonable, and second of all, what led to the enactment of this statute was not the content of the speech, but the turmoil around the clinic.
Is there a stand your ground provision here?
Yes, Your Honor. Unlike Shank, which had a 50-feet fixed bubble provision that had not a stand your ground provision, it was held unconstitutional because if you were protesting and somebody approached you, you have to keep moving in order to be 15 feet away from the other person. In this case, if you set chop, people can approach you and you'll be exempt from liability.
Do counter-protesters, so there's a history of protests and counter-protests at this clinic. Would counter-protesters also have to abide by the statute in terms of the fixed buffer and the floating buffer?
Absolutely, Your Honor. If we read the terms of the statute, it prohibits anybody who knowingly engages in speech that could be considered protesting, counseling, or educating. So even if I went there and I start protesting about the possible involvement of the U.S. in the war in Syria, I'll still be held liable under the statute.
Don't you find the restrictions a bit overbroad, especially when what brought us here was the fact that the Reverend stopped a person who wasn't even going to the clinic for services, but someone totally going for a totally different reason?
Yes, Your Honor, but Reverend Baxter violated the statute by approaching this person within 12 feet without the person's consent and engaging this person in a matter of protest by calling her a baby killer and by holding a sign that says, "Choose life." He didn't violate the statute because of the content of his speech, but because he was protesting within 12 feet without the person's consent.
Don't you think the exception inherently favors those who are advocating the pro-choice position or advocating abortion in specific cases?
Well, Your Honor,
you certainly wouldn't expect an employee or agent to go out and assist a client into the facility all that time trying to talk the client out of the procedure, would you?
Your Honor, the fact of the matter is that Reverend Baxter and people that have different views against abortion still have ways to get their message across. The statute to employees only...
You don't think that stacks the deck?
I believe that it could be seen also a little bit as a biased point of view, but we got to remember that these people are acting within the scope of their employment. It is their job to walk the woman entering into the clinic.
And the Reverend is acting within the scope of his conscience.
Yes.
For which he's not paid.
Yes, Your Honor, but we gotta look at the circumstances that led to the enactment of this statute. They were engaging in face-to-face confrontations with the women entering the clinic. They were harassing. Sorry.
Does the escorting actually is that conduct? Could we look at that exception for clinic employees to escort their women into the clinic and view that as conduct rather than speech? What if the escort says nothing to the woman whatsoever and merely just links arms with her and walks her into the clinic? Does that somehow help your argument?
Yeah, yes, it would, because
Absolutely.
because then the employee will not be engaging in any kind of communication.
Does the First Amendment give you the right not to listen to somebody?
The First Amendment.
Do I have the right to refuse to listen to somebody?
Yes, you have the right to refuse to listen to anybody. But
is there less protection under the First Amendment when the method of spreading your word is face-to-face, in-your-face confrontation?
Well, Your Honor, although the First Amendment protects our right to freedom of speech, this is not absolute, and it has some restrictions. Some of those restrictions are, for example, fighting words through threats, and in this case, the government has said that when a government places a content-neutral restriction on time, manner, and place, it will be held constitutional.
Should we be more sensitive where you have face-to-face confrontation where it's hard for the person to walk away? If somebody's standing on a street corner, I can walk away. You don't have to listen to it.
Yes,
if somebody's tracking me into a place, the risk of face-to-face confrontation is much greater. And should there be lesser protection for that?
But, Your Honor, the record clearly showed that women stopped attending the clinic out of fear of being confronted by these people. They were engaging, they were following these people, they were following the patients, they were engaging them in face-to-face.
There was also an uptick then subsequently in the number of clients at the clinic, was there not?
The number of patients attending the clinic decreased when the Reverend Baxter and his church was engaging in protests outside the clinic.
Well, is that something that the court should be concerned about, and why?
Because this clinic is the only reproductive health care facility in the state that still practices abortion. Abortion is still protected.
Doesn't that fact suggest that that's why the legislature specifically targeted?
But the legislature...
Because it was an abortion clinic, because it was a reproductive health clinic.
But, Your Honor, the legislature didn't target the content of the speech. It targeted the way it was delivered. And it is an interest of the government that women have proper access to reproductive health care facilities.
Well, if that's true, and the government, through the statute, is targeting a reproductive health clinic, isn't this more like an injunction than a statute? Shouldn't the court's standard of review be sort of different and perhaps stricter, because we should treat this as an injunction, which is what it really is?
Your Honor, even if the court was to treat this as an injunction, the letter of the text does not burden any more speech than necessary because of the stand your ground provision and because there are alternative methods of communication. For example, nothing in the statute says that Reverend Baxter can bring speakers and deliver his message. The statute also says that he can approach somebody if they give consent to him. The statute also says that if he stands his ground, he can actually set shop in the parking lot and welcome anybody that wants to talk to him and educate him about his point of view. Time?
You may continue.
Thank you. Because this is a content-neutral restriction, the proper level to use in this case is intermediate scrutiny. Sorry. Can I just conclude, Your Honor, very briefly? What's at stake here is the woman's rights to enter reproductive health care facilities. If this statute is not held to be constitutional, this will really be a slap to the face to the women's rights movement.
I hate to go late question. Assuming you lost the issue of content neutral, and we determined that it was not content neutral, do you concede that you lose the case?
No, I don't, Your Honor, because under a content, if it's content-based, under a strict scrutiny level, this statute will still pass because it serves compelling governmental interest, which is promoting access to reproductive health care facilities in a state that only has one reproductive health care facility. Thank you.
Thank you. We'll hear then from Petitioner 2, or Ms. Ockert.
Good afternoon, Chief Justice Smith, Your Honors. May it please the Court, my name is Aruna Chittayappa, and I represent the petitioner, Camelia Ockert, on this appeal. May I please reserve 1 minute for rebuttal, Your Honor?
Granted.
Thank you. The media is the practical gatekeepers of our First Amendment right to free speech and freedom of the press. Ms. Ockert published a video that contained private information between a minor and her doctor, as well as information that concerns the public. In this particular case...
Let's stop right there. What was the information that concerns the public?
Yes, Your Honor. The subject matter of the video, which is at dispute here, is that there was Katerina Baxter, the 16-year-old minor, talking to her doctor about methods of getting an abortion. Integral to a minor getting an abortion is parental consent. A document was passed when the doctor said, Katerina, you need to have parental consent. A document was passed which seemed to indicate that parental consent had been obtained.
You've very accurately, from my understanding of the record, recited factually what occurred here, but I want to know why all of that constitutes an issue of public concern. Where's the public interest in knowing anything about what this young woman said to her doctor and what the doctor said in reply?
The parental consent in this case, Your Honor, triggers the public concern because Katerina's parents, and in this particular case, her mother, Kate O'Neill Baxter, is a public figure. And the public concern stems from the fact that there is a substantial incongruity.
How are they public figures? We're not talking about Martin Luther King Jr. or even someone running for public office. We're talking about a family in the community. How are they public figures?
Your Honor, the Baxters, Reverend Mark Baxter and Kate O'Neill Baxter, may not be elected public figures. However, the public places their trust in them, and they hold leadership positions in their local church. And the fact that...
So the children of public figures lose their privacy rights just by being born of these people?
No, Your Honor, but the fact that the mother's consent triggers, the mother's consent is integral in the conversation in the video. And this consent drags Katerina into the public limelight.
Well, that definitely is the effect of it, but I'm still starting I'm still at my first question, which is to try to identify what the public interest is. We all know that, as a matter of fact, this young woman was dragged into the public square as a result of this controversy. But what is the interest? Is the interest in demonstrating that the Reverend and or his wife is a hypocrite? I mean, is that a public interest issue?
The hypocrisy of their statements is one of the major concerns at issue here, Your Honor. Moreover, when you do have a public figure that demands the attention of several people, and there is a call to arms to attack abortion clinics, and influences the topic of abortion in the state of Froessel, not just on a local level, but on a statewide level, the public does have a right to know that these public figures are saying one thing and doing one thing in public and doing another thing in private. And their personal morality is at issue here because their decisions do affect the lives of several people, thousands of people in the state of Froessel.
Well, let's focus on the child. Isn't the child in this case the victim? How is her health and her actions relevant to the public? Why is it public interest?
Yes,
The child itself, the minor.
The minor does have a right to privacy. And furthermore, the communication between a doctor and Katerina Baxter in this case is in most instances protected by doctor-patient confidentiality. However, the topic of a minor obtaining an abortion involves getting parental consent. And the video shows a document being passed to the doctor that purports to indicate that express consent was given by either one of her parents.
But, Counselor, isn't the issue here really there's a difference in how we would rule on the exposure of the private information as to the parents versus the private information as to the child? So that let's say we agree with you that the parents are public figures and the public has a right to know. Is there some way that the court could find that this video should have been edited or that certain information is okay to publish but other information is not? Or does the whole thing have to come together as one?
Unfortunately, Your Honor, the manner in which the video was uploaded was from a third-party anonymous source who illegally obtained this video. And the way in which user-generated content operates on such a website, such as the Mendic Times, is that the administrator may only take down the information if it violates, if it's abusive, or there's some other issue at stake.
Couldn't the administrator do whatever he or she wanted? I mean, edit it, turn it down altogether? I mean, he wasn't forced to accept it in the form it was uploaded.
Yes, Your Honor. I do agree that the argument that the video may have been overly expansive, that the information was there that didn't concern Katerina. However, the main topic of the video introduced was look at the hypocrisy of pro-life parents who make their 16-year-old daughter get an abortion.
The only thing that showed that was the consent that the mother gave. The whole rest of it had nothing to do with the public interest, did it?
No, Your Honor, because the conversation showed in the video...
In fact, it was contrary to the public interest, wasn't it? I mean, we have a long-standing jurisprudence that creates and protects various privileges, such as communications that go back and forth between a patient and a doctor. We have a huge statutory structure at the federal level known as HIPAA that's designed to a great extent to assure confidentiality of medical records. It seems to me that there is just a whole array of expressions of public policy out there which are aimed at keeping private records and conversations between any patient, let alone a minor patient, and a doctor. How do you overcome that kind of strong public policy preference, which is also expressed at the tort level in the availability of a tort for the public revelation of private facts?
In this case, Your Honor, the fact that Section 3.15 of the Froessel Medical Privacy Act attempts to hold Ms. Ockett liable for publishing information, for information that she was not involved with. She did not illegally intercept this information. She knew
it was illegally intercepted.
Yes, she did, Your Honor.
Isn't that a huge problem for you?
The fact that the way the statute is constructed, the way the provision is constructed, is that Ms. Ockett could be held liable for knowing or should have known that the information was unlawful. However, in Bartnicki versus Vopper, decided by this court in 2001, there was a similar known or should have known provision in that case. And this court held that the radio broadcaster did violate the known or should have known provision, but his First Amendment right prohibited the suit altogether because in that case, in Bartnicki, as in our case, we have a third-party source who illegally intercepted the information and passed it on to the radio broadcaster.
But that case is very fact-specific. I don't think that case can be applied here. The facts here are very different. And why don't we take into account the consequences of this publication to the family and to the child? She received a lot of emails. She received threats. They had to move away. Isn't that something that we should also take into account?
Your Honor, we should take into account the unfortunate consequences of what happened to Katerina and her family. However, this court has held that that is not enough and does not satisfy the standard as set forth in Daily Mail, Smith versus Daily Mail Publishing Company, where the state is under a strict scrutiny standard to show that its interests are of the highest order and must.
But Daily Mail, that information was obtained legally, correct? And that's
Yes,
a very
Your
big
Honor.
difference than what's happening here. And in Bartnicki, I think the big difference also is this issue of the public figure. And in that case, there was an election going on, right? And there was conversations about people who were running for office and things of that nature. Is that right?
No, Your Honor. In Bartnicki, it was.
Union, that was the teachers' union.
Yes, it was a contract negotiation.
But there was a concurring opinion which two justices signed that said this is limited very strictly to the facts of this case, which was a threat of physical harm, was the facts of this case.
Yes, Your Honor.
Bartnicki.
Public education is clearly an issue of public concern, along with the union activity in Bartnicki and the prospect of a strike, right?
Yes, Your
That's
Honor.
an easy one.
Your Honor, to address Justice Soto's question, and then I will, in return, answer yours, the consequences to what happened to Katerina are unfortunate. However, in Florida Star versus BJF, decided by this court in 1989, the rape victim was, when her name was published by a newspaper, had received threatening calls from the very man who raped her and had to relocate, change her address, her number, seek police protection, and also obtain emotional counseling.
But wasn't her name gotten from a public source?
Yes, Your Honor.
From the government papers.
But the fact that the state's interests were not justified and the media's right to publish the information was still upheld by this court, irrespective of the consequences of what happened to the victim.
Counsel, let me go back to what I started with earlier. The Mendick Times could have easily amended or edited the information they had to publish what was of public interest, which was the fact that the Reverend's wife had consented, and leave out almost everything about the young lady and her counseling, what she learned. It would have been very easy to do. So there was willfully put in there a lot of material that just simply was not of public interest, which almost overwhelmed the one fact that was of public interest.
No, Your Honor, because even though the video did indicate did show that Miss Katerina Baxter did have HPV, however, the crux of the issue concentrated on the fact that she obtained an abortion. And so much so strong was the public concern that the state of Froessel conducted an official investigation into the matter just to determine that consent had been obtained. Justice Soto, to answer your question regarding the facts of Bartnicki, they are not factually exact to our case, but the public concern in Bartnicki is substantially less than the public concern here. In Bartnicki, the public concern is localized. It was education to one high school, and this court upheld that as a sufficient public concern to justify not holding the radio broadcaster liable. In our case, the public concern is at a statewide level. And thus, though the invasion of privacy is greater in our case, because we do have a 16-year-old minor, the public concern does justify the greater invasion of privacy.
Why is it a statewide issue? We're talking about the reverend of a local church with congregants presumably from the local community. Why is it a statewide issue?
Your Honor, even though Reverend Baxter is the local leader of a small church in the small city of Franzia, he commands a lot of attention on the topic of abortion and regularly protests outside Family Solutions, which is the sole abortion clinic, so much so that his effect of his efforts, words, and actions forced the state legislature to enact a time, place, and manner restriction to regulate where he can protest. That's how important his words are in the state.
It's the only clinic in the state, isn't that the real answer? It's the only abortion clinic in the entire state.
Currently, Your Honor, yes, due to the efforts of the protesters. Because 2 other clinics had to be shut down because the effect of Reverend Baxter on the public discourse is so important. And thus, he is a public figure. And his consent, rather his wife's consent in the video, triggers the fact that the public has a stake in knowing that the people whom they follow, the people whom they go and whose, may I briefly conclude? The people whom they follow are public figures. And when their consent is expressly implicated in a video, then it is a public concern.
Thank you very much, counsel. We'll have you back on rebuttal.
Thank you, Your Honors.
We'll hear from counsel for Reverend Baxter.
Good afternoon, Chief Justice Smith, Your Honors. May it please the Court. My name is Naveed Froessel, and I represent the respondent, Reverend Mark Baxter. Reverend Baxter respectfully asks this Court to affirm the appellate court's decision, which found Section 3.14 of the Froessel Medical Privacy Act to be unconstitutional. Reverend Baxter is a man who simply exercised his fundamental First Amendment right under the United States Constitution to protest the act of an abortion alongside his wife and congregation. The state of Froessel enacted Section 3.14 of the Froessel Medical Privacy Act, which expressly strips my client of his fundamental First Amendment right.
How does the statute strip your client of his fundamental First Amendment rights when he can absolutely protest, express his views? He only cannot interfere with other people's ability to use the health clinic.
Your Honor, that is because the statute is content-based. It strips my client of a First Amendment right by not allowing him to protest outside of the one reproductive health care facility where abortions are legal in the entire state of Froessel.
Protest. He just has to stay back within 50 feet, isn't that true?
Yes, Your Honor, that is true, and as said in the record. But if we envision the way the 50 feet works, the clinic is in the middle. There is a 40 feet of within the entrances and the parking lot, and an additional 10 feet that extends to the end of the sidewalk. That is a 50-foot radius around the entire reproductive health care facility, pushing my client to the street. At this point, my client is forced.
His ground. He can set up as long as he doesn't move and chase the person into the. He can stand there and he can stand near an entrance, and they have to go by him. He can hold a sign
and speak.
Yes, Your Honor. While it is true that there is a stand your ground provision in the statute, there are also 4 entrances and exits at this reproductive health care facility.
So 4 people can stand their ground.
Yes, Your Honor, that could be plausible. Yet the fact of the matter is that any man or woman deciding to go into this reproductive health care facility can take special measures to avoid an entrance or exit where Reverend Baxter.
Right? That's not the problem with the statute. That's someone's right to have to, as we were talking before about not having someone else's message being forced upon you.
Yes, Your Honor, while that is true, my client's right to First Amendment speech is also important in this case.
He has the right to speak. Does he have the right to force somebody to stand there and listen to him?
No, Your Honor, there's no right for someone to force you to listen to them, but my client is being restricted on the kinds of speech that he can have and protest in his own decision to approach the reproductive health care facility. If the state's true interest were to protect access to medical facilities, then the state should have enacted a statute that was for all medical facilities rather than just one reproductive health care facility.
Isn't Hill a problem for you? I mean, this court in Hill said that the statute in that case, quote, simply establishes a minor place restriction on an extremely broad category of communications with unwilling listeners. Instead of drawing distinctions based on the subject that the approaching speaker may wish to address, the statute applies equally to used car salesmen, animal rights activists, fundraisers, environmentalists, and missionaries.
Your Honor,
I mean, if that's the case, and given the similarity in the broad category of communications between our statute in this case and there, I mean, isn't that game, set, and match? Don't you lose?
No, Your Honor. The Hill case is different from the facts of the matter here. The Hill case also held that the court in Hill also held that it did not establish any categorical rule restricting communications among citizens in a public setting, but rather establishes a case-by-case basis. Additionally, the Hill case focused on that was facially unconstitutional. This statute is unconstitutional as applied to Reverend Baxter in the way that he's able to communicate to men and women that enter this reproductive health care facility.
Even if you apply the strict scrutiny test, can't you find that this statute is so narrowly tailored and it is the least restrictive means of the state making sure that people are able to go into the clinic, that there are no protests that hurts 4-year-old children, that there's a free-flowing traffic in the street? Doesn't that qualify?
Well, Your Honor, under the strict scrutiny standard, the government has to prove that they're using the least restrictive means to attain the state's interest. Where here, looking at the statute of four corners of the statute, it is not the most least restrictive means. It's exponentially more than that.
What would be the least restrictive means? What should the statute say?
The statute should include a lower radius, including a lower floating bubble provision.
What number? How many feet?
Within 20 feet, so that my client would be able to still stand in the parking lot and be face to face with someone to get his point across. The stand your ground provision is not the same of having his congregation, including Reverend Baxter, to be there to get his point across. There's an exception in this.
Same. You could set up near the 4 entrances. Why is it any different?
Well, Your Honor, as I stated previously, there's still 4 entrances and exits, and while he may be able to set up shop at each of those, the clinic also, the reproductive health care facility also has its own intentions to keep their patients away from them so that they get as many people inside there to get an abortion as possible. There's also an exception in the statute for authorized agents and employees. An authorized agent can be anyone. An authorized agent can be a community member who is a volunteer that has their interest to be pro-abortion to bring a patient there and counsel them. The record itself expressly states, and I quote, "Family Solutions instructed volunteers to approach patients by introducing themselves and declaring their intention to help the patient enter the clinic." That statement, declaring their intention to help the patient enter their clinic, this is in of itself counseling. This is giving the authorized agent or the employee the opportunity to get them to enter the clinic and counsel them to be pro-abortion. A person can change their mind at any minute, whether they're choosing to get an abortion at any second. And my client deserves the right under his First Amendment to be there and have a balanced power instead of an unbalanced power to be able to relay his point of view as well as.
My earlier question to your opponent, I had asked if the statute allowed for no communications between the person escorting the woman into the clinic and the woman entering the clinic. Let's say it just allowed for the physical act of escorting. Would that remedy any sort of issue you see with any of the content-based concerns?
Yes, Your Honor, it would still be content-based because by the state only focusing on this one reproductive health care facility, it knows that Reverend Baxter and his congregation were focusing their efforts on the single legal abortion clinic in the state.
Does the government have the right to protect clinics, particularly because the right to access abortion is constitutionally protected? There isn't any other medical procedure that is constitutionally protected, and so doesn't that therefore give the state an interest in passing this legislation?
Yes, Your Honor, while that may give the state an interest, the state should also, my client still also has an interest in protecting his fundamental First Amendment right. The state's interest is to protect access to medical facilities. They never said their interest was to protect access to the single abortion clinic in the state. If that's the case, this is called the Froessel Medical Privacy Act. This should apply to all medical facilities and not just the one reproductive health care facility that is where abortions are legal in the state.
Counselor, bringing you back to your First Amendment argument about your client's rights being violated because people could escape your client's presence, I'm just wondering where in the First Amendment you find support for your argument that your client's First Amendment rights are somehow violated if the people that he is targeting can get away. Why does that infringe on your client's First Amendment rights? If they can avoid him by entering through another entrance, how does that affect your First Amendment argument?
Well, Your Honor, the statute itself in its context has restricted my client's First Amendment right because it excludes protest, education, and counseling.
But if he can protest, I thought your argument was it doesn't interfere with his ability to protest. It only interferes with his ability to kind of corral his audience and keep them there. Where is his right to do that?
Well, Your Honor, even if my client has the opportunity to stand his ground in the parking lot, number one, is not going to be as effective, and number two, he still has to obtain the consent from a patient going in and around him to speak to them. And no
client. Do you think he should have the right to chase a patient? I mean, that's what you seem to be arguing, that he should be able to chase the patient no matter how the patient wishes to avoid him. so we can confront, face to face. Is that what you think the First Amendment says? That you
No, Your
right
Honor.
to chase down a patient?
Excuse me. No, Your Honor. I'm not saying that my client should be able to chase a patient. I'm saying that
But that's the practical effect that you want. You want him to be able to see the patient going in the door to follow him, chase him down until he could confront him.
No, Your Honor. I'm not saying that my client should afford the right to chase a patient. I'm saying that my client affords the same right the clinic has.
That's what happened here. He chased after someone.
Yes, Your Honor.
And shouted epithets. Will you explain your as-applied theory here? I know you've attacked the statute both facially and as applied, and I'm not sure I understand your as-applied theory.
Yes, Your Honor. To address your first question, Chief Justice Smith, while my client did chase after Catherine Cabral, the First Amendment right still protects my client from yelling prostitute or murder as much as it protects his First Amendment speech or the right for the clinic to counsel a patient. And addressing your second question, Chief Justice Smith, could you please repeat your second question, the as-applied theory?
What is your as-applied theory here?
Your Honor, the statute, Section 3.14 of the FMPA as applied to Reverend Baxter is still content-based because it only applies, he still doesn't have the opportunity to protest as effectively as he can, and it only focuses on this one reproductive health care facility rather than all medical facilities.
Even if it is content-based, though, there can be strict scrutiny.
Yes, Your Honor, and under strict scrutiny, it shows that the government is supposed to use the least restrictive means. By enacting a 12-foot bubble, a 50-foot radius, an exception for authorized agents and employees, burdening more speech than necessary, it fails under the strict scrutiny test as well. Additionally,
Do you concede, going back to actually the arrest that happened here, do you concede that the arrest was warranted under the statute as written and also as a statute that you seem to think would also be constitutional? If there was a 20-foot fixed buffer zone and Reverend Baxter was chasing down a patient, that he would have violated that hypothetical statute as well?
well, Your Honor, looking at this, focusing on the statute that's here right now, while my client did get arrested and cited for violating Section 3.14 after chasing...
It's only civil liability, isn't it?
Yes, Your Honor, it's civil liability, and there was a fine for $250. But that still doesn't give my client the opportunity under the First Amendment to effectively relay his point, just as the clinic has, under their own exception, can go there and counsel a patient as they're walking in.
But in terms of my question, do you concede that what he did was improper under the statute by chasing down the woman who was entering the clinic?
Yes, Your Honor. Under the statute at hand, what he did was improper under the statute, but that doesn't mean that my client still doesn't afford the fundamental First Amendment right.
Any statute in any form that would have been legal conduct, chasing somebody down and hollering epithets at her?
Your Honor, my clients, but yelling these epithets is still covered under the First Amendment right, just as much as the clinic has their own First Amendment right to their own freedom of speech and expression. But that's not the fact of the matter here. By their force.
Do you think that to be constitutional, a statute would have to permit him to do what he did in this case? If there was no way of drafting a statute that would not have forbid that conduct, is that your position?
Could you please rephrase that question, please?
All right, I'll try to rephrase it. Is there any form of statute, in your view, that would be constitutional that would forbid what he did to that woman that day?
Well, Your Honor, I'm saying that while he did chase down Catherine Cabral and while that was against...
that's not my question. My question is there any way this statute could be tightened up to pass, in your view, to pass constitutional muster that would not have allowed that conduct?
Well, Your Honor, if my client had the freedom and able to approach any person in the parking lot and relay his point of view face-to-face and speak calmly and be able to...
We know what happened.
So the statute's at fault for causing him to go chase the woman and shout at her? Is that what you're saying?
No, Your Honor, I'm saying that if the statute should give my client the right to go up to a patient entering and relay his point of view just as much as it gives the authorized agent or employee.
That's not what Justice Arenas is asking. Let me ask a version.
Ask it more clearly than I did.
No, I'm sure if what you're saying is to be justified, how would any disorderly conduct statute in this country withstand constitutional attack?
Well, Your Honor, I'm just getting at the fact here. I'm not saying that that statute shouldn't be there to protect Catherine Cabral. I'm just saying that focusing on the statute while he did violate the statute, I want to focus on the fact that he still has, my client should still have the right to exercise his freedom of speech. And I understand that.
I'm going to try one more time. Let's assume we had a statute with a 2-foot bubble, a 10-foot radius around the entrance, and no provision for agents or employees. More like Colorado versus Hill, but with even tighter than that. Would it be constitutional?
Would it be constitutional?
Yeah, because that would forbid. His conduct would have violated even that statute.
Well, Your Honor, a smaller radius and a smaller floating bubble. A smaller radius and a smaller floating bubble would, in fact, help my client. And
no, for what he did that day, he still would have violated a smaller bubble, a smaller radius, no agents involved. Would that statute be constitutional?
I still find the statute would be unconstitutional because it still burdens my client's fundamental First Amendment right.
Thank you.
Thank you, Your Honors.
We'll hear from counsel for Respondent Froessel.
Good afternoon, Chief Justice, Your Honors. May it please the Court, my name is Michael Froessel, and I represent the state of Froessel on this matter. Today, we ask this Court to uphold the ruling of the United States Court of Appeals for the 13th Circuit and find that Section 3.15 of the Froessel Medical Privacy Act is constitutional as it provides to Ms. Ockert for the following 3 reasons. First, this is not a matter of public concern because Katerina Baxter is not a public official and the content of the video is not of public interest.
Do you agree that her parents, however, are public figures?
Her parents have been in the public eye on this one particular issue.
That doesn't answer the question. Are they public figures or not?
In this particular instance, yes, her parents are public figures. However, that does not automatically implicate that Katerina is a public figure.
Does Katerina have to be a public figure if the idea of releasing this video online through the press is to get an issue of public importance out to the public? Does everybody who might have some exposure have to be a public figure, or isn't it enough that there's an issue of great public concern that justifies it?
In this particular instance, it is not enough that there is just a matter that could concern the public, because it is implicating, in this instance, Katerina Baxter, who is not a public official. We cannot simply drag in anyone who is associated with an instance, especially if they are private figures.
But the contents of the video was true, and the public does have a corresponding right to know.
In this particular instance, they would only be interested in the one matter of the consent. However, the video in its entirety, as was pointed out by Justice Arenas, only the consent form in and of itself was of interest. Everything else in the video was not for the public to know. They had nothing to do with it.
How can you isolate the consent from from Katerina's abortion? Don't they go hand in hand?
Admittedly, in this instance, they are very closely linked in a tight matrix of facts. However, it is also because of that we have to look at the totality of the situation.
Why should we be more protective of Katerina's privacy than of minors' privacy in these other cases that this court has decided that there's a greater public interest even though there's a minor involved, as in Smith versus Daily Mail or Florida Star?
In the 2 cases that Your Honor has just cited, Smith versus Daily Mail, in that case, the information was obtained legally. That's
a different issue. We're still talking about whether a minor's privacy trumps everything else when there's an issue of public concern. Why should that minor's privacy just trump all of the other public concerns, the freedom of the press, which involves the right of the public to hear information, not just the press's right to express information?
Because in this particular instance, Your Honor, it is not simply the right of privacy of the minor that is at stake. It is also the right to receive an abortion that this court has upheld.
How do you distinguish Bernicki?
Bartnicki?
Pure and simple. How do you distinguish Bernicki, Supreme Court?
The case of Bartnicki versus Vopper is actually distinguishable on one key point. In the instance of Bartnicki versus Vopper, we had an instance where there was illegally obtained information by a third party that eventually made its way to a radio who published the information. However, a fact that is frequently overlooked in Bartnicki versus Vopper is the key distinguishing point. The information was first given to an individual by the name of Yumkov, and he was actually affiliated with these debates on the strike. He received the tape, he listened to the tape, but then he actually took it one step further, and he played the tape for various members of the public. It was Yumkov who began the distribution to the public that began this circulation. Only then did Yumkov take it himself and bring it to the radio station.
Did our analysis turn on that point, however? That seems to be an interesting, very detailed, factual point, but I'm not sure that our ultimate holding rested on that particular distinction.
The analysis in that point determined that the media legally obtained it, but it was because of this defect in the chain from those who initially obtained it to those who initially distributed it in the media. It was Yumkov that was the defect in the chain that prevented.
Legally obtained. It was an illegal wiretap. When it was published ultimately by the press, they knew it was illegally maintained. There was no secret about that. It was an illegal wiretap.
But they were
trying to figure out why the facts that this intermediate conduct had anything to do with the analysis of the court.
Because in that instance, Yumkov wasn't acting as an agent who specifically had obtained the illegal information. He was acting as a source providing information. He was not directly involved in the distribution once it was immediately obtained. It was given to him, and then he passed it along. That's an important distinction from the current case, where Ms. Ockert had direct relations and had to approve the information to be published. It was taken from the site Anonymous. However, we can conclude that Anonymous was related to the stealing of the information because as soon as...
Why can we conclude then?
Because the record shows that as soon as the information was published by Ms. Ockert, it went viral. Not only did it go viral, but other media sources began picking it up and leaking it and talking about it.
No, but your conclusion was that Anonymous was involved with the theft. Where does that come from?
In this instance, the record can show by looking at the facts after publication that had Anonymous been a medium, they would have acted like Yumkov, and they would have distributed themselves and began public dispersion. However, there is no evidence on the record to suggest anything of that sort. In fact, it was Ms. Ockert, by publishing the information, by reviewing it, that brought it into the public's discretion. And in fact, that raises an interesting question about Ms. Ockert. Ms. Ockert is a publicly proclaimed pro-choice advocate, and she is utilizing an individual receiving an abortion, a 16-year-old girl, an innocent, to get back at a public figure, an embarrassment.
Does that matter? Does her motivations matter?
It shows that she could have approached the information very differently than just looking at it from an objective concern.
How is that relevant under the statute? Does that affect her mens rea for some reason under the statute, or what tie it to the statute?
Yes, the statute one of the aspects of the statute is a mens rea intentionality. And when it is received and reviewed, when it's being dispersed by the media, if they intentionally know that this information has been stolen, that it is illegally obtained, that they are responsible for it.
But that's knowing that it's illegally obtained is different from I'm a pro-choice advocate and therefore I want to embarrass Reverend Baxter, isn't it?
It demonstrates in this instance, Your Honor, that the fact that she knew this information, it was no secret that it was stolen, and she was taking the opportunity just to get back at someone.
Why is this different from Bartnicki?
Because in that instance, Yumkov may have given it to the media, but the media had no place and personal basis on distributing the information. Yumkov may have been the individual who had interest in whether or not this tape showed something discrepancy. However, the media in that instance, they had no interest in it besides the fact that it was public concern.
But Bartnicki calls for a balancing test, doesn't it? Mm-hmm. So assuming that Bartnicki is the yardstick that we employ, how should we balance under Bartnicki?
The Bartnicki balancing test would ultimately be weighing the interests of Katerina, in this instance the state of Froessel, against the freedom of the press. In the case of Bartnicki v. Vopper, they were looking at strictly the right of privacy against the freedom of the press. In this instance, however, it is not simply the right of privacy against the freedom of the press. It's the right of privacy, the right to receive an abortion, the doctor-patient confidentiality that we hold so dear, the right to protect a minor and ensure that they are safe, the right to prevent yourself from harm and ensure that you are free to live your life in pursuit of happiness. That is what's being weighed against the freedom of the press. That is, in terms of the balancing test, what is greatly distinguishable from Bartnicki v. Vopper. In this instance, it is not just Katerina and Ms. Ockert that we're dealing with. It is the implications of the ruling in this instance. Not only could we say Katerina can be harmed, but then we can travel down the road and say anyone that is merely born to a public official automatically is waiving their right to privacy because they did something that they had no control over.
Isn't there, at common law, the existence of a tort of public disclosure of private facts?
Yes, Your Honor.
But what's the difference between the remedy provided here, which is a civil remedy under the statute, and this tort that I think is provided not only in common law, but it finds a place in the restatement of torts?
In that instance, Your Honor, the remedy in both cases are similar. In this instance, the remedy that the legislator has provided are indeed civil liabilities. However, we could also take a look at the restatement of torts. An element of that very tort is that the way the information is distributed and given to the public is important. If for some reason the public were to be morally dispugnant at the information they have been given and the way they had to find it out, that could very much take it out of being that very tort.
That was actually a softball question.
So.
I was going to say, you can count the stitches on the seam.
Apologies, Your Honor. Well, that could actually lead us to the other standard that we are addressing, and that is the 1979 case of Smith versus Daily Mail. In that instance, as we've already spoken about, it has to be an interest of the highest order. In that particular case, as we've already said, the information was legally obtained from government documents that had already made them publicly available.
But does that affect whether it was an interest of the highest order? Didn't the court say there, even though the privacy of the victim of an assault was leaked to the public and she could have been exposed to threats and violence, that was not an interest of the highest order?
Smith versus Daily Mail, actually, Your Honor, dealt with a school shooting from the police and the information being gathered from a witness.
Right.
I believe the case that Your Honor is referring to, though, is the Florida Star versus BJF case.
That's correct.
Yes.
And in that case, the court did say it wasn't an interest of the highest order. In fact, anytime someone's privacy is violated, and especially a minor, there's the risk of violent threats, and that's not usually enough for the court to say that's an interest of the highest order. Isn't that correct?
In this particular instance, Your Honor, one key difference between Florida Star versus BJS and the current instance is that there's actually a case, in fact, one we've discussed, Bartnicki versus Vopper. The court explicitly stated that because of modern views and the changing of the ways things are progressing, the right of privacy is now a right of the highest order. It's an interest of the highest order in the state. So that is one key difference between when the court decided the opinion in Florida Star versus BJF and the current instance.
So your argument is any time the privacy of an individual is exposed in the media, that their privacy should trump the freedom of the press?
No, Your Honor. That is taking the argument to a next extreme.
Let me ask, let's assume in this case the editor had edited the information, the stolen information, to leave out everything that they could other than the fact of the parental consent, which is the matter that seems to be of most public interest. What would be the result in that case? If the editor just focused on that, left out everything about the conversation between the doctor and Katrina, and just put in only the fact that the mother had consented, and that was the focus. Should the statute be upheld in that context?
In that instance, the statute should still be upheld, Your Honor.
Why?
In that instance, we would be showing that, indeed, the parent signed the consent form. However, as we've already stated, as opposing counsel stated, the consent form is needed by a minor to receive an abortion. So still, by distributing this consent form to the public, we're still showing that the minor has received an abortion. And also, we know that...
No, it just shows that she consented to one, not that it took place or Under what circumstances it took. All we know, if the focus was that the mother signed a consent, because that was what was investigated by the authorities, was that very issue. And it turns out she did sign the consent.
However, in that instance, Your Honor, it would still show that in the very least, Katerina Baxter is seeking to invoke her right to an abortion. She is still seeking, even if it has not necessarily occurred as of yet, it is still showing that she is going through the process and is asserting that right, at least to gather more information on it.
Is there anything in the record about whether the Baxters have more than one daughter? In other words, would we have been able to deduce that it was Katerina rather than another daughter of the Baxters by the mere fact of this consent form?
The record does not disclose any information or any indication that there is any other daughter or sibling or child of the Baxters, so it would suggest this consent form that it is only for Katerina Baxter. If there were another child, that would actually be very pertinent as the consent form, if leaked alone, as the hypothetical is instance, it could lead to other deductions, and it wouldn't lead directly to Katerina.
On the other hand, it would cast two daughters under a cloud and questions as opposed to victimizing one.
Yeah, it could. Your Honor is absolutely correct. It could very well bring both of them into the.
That was a softball too.
Yes.
You stop it.
I'm incorrigible.
So, in conclusions, Your Honor, it is very clear that this case is a very delicate one. The balancing test must be struck. However, may I briefly conclude, Your Honor? It must be kept in mind, however, that it is not just Katerina who is at stake here. It is any child of a public official. This ruling could very well lead to terrible things down the road, because what now is simply a child may turn into a spouse or a close friend or a family relative that is very distant. Like, where does it end? We need to strike and show that in these instances, that the fact that an individual can go to a reproductive health care facility, maybe even one like the current instance, where there already is hesitation to approach because there's violent protests outside.
All right, we understand your position, counsel. Thank you.
Thank you.
Rebuttal?
I will be very brief, Your Honors. I just want to point to the fact that opposing counsel said that as applied to Reverend Baxter, the statute was unconstitutional because it restricted his points of view. That's incorrect. If Reverend Baxter would have been talking about anything else that could be considered education, protesting, or cancel, he'll still be held liable under the statute. Thank you.
Rebuttal?
Your Honours, I would just like to respond to respondent's distinguishment of Botnicki from our case, in which the court said that Jack Yuko, though he may have created a longer line of custody of the information in question, had no bearing on the case. Because at the end of the day, we did have a third party who illegally intercepted information, and by promoting a shoot the messenger policy, could not hold the radio broadcaster liable, which is directly controlling on our case. Thank you, Your Honours.
Thank you very much to all of counsel. The case was well argued by all, and we will right now take the matter under advisement and come back with a decision a hell of a lot quicker than any court that I know ever could.
You've not been to my court.
All right.
It's a part.
It's like watching your thing. It's like watching I make my back.
Yeah, don't be so biased.
I can't. I love it.
Thank you.
I was on the edge of my seat.
I literally was trying to admire
Actually, it was a compromise. The judge was strong. I'm not done. I have to. No, I'm gonna go there and say congratulations.
I never thought that I would.
Thank you. You'll see a lot of this video. Of me behind you. I'm so I couldn't do it now. I was shaking. I was shaking. See my legs? My knees were not together. I can tell you guys are all very steady. Oh my god. I'm sorry. I know, everyone was this year. I know. I was thinking about that. Even it is. They were really good. So much. You know what? It's so cute. What was the interaction between the two? Yeah. I was like, oh my god, how cute. Yeah, they were really, really nice. And like, not nice. She was like tricking about thinking she was like, this is about da da da, and I was like, no. It's. I know, it is. It's not for like 2 minutes. I know, I'm like, yes, I'm that bitch who wants 16-year-old.
Yeah, they'll be pretty quick about it. Last year they were. It's really tough. It's I was impressed. I was so impressed.
Are you learning how to breathe again as well? Yeah, she's standing there. You could,
He doesn't know what he's talking
when you are answering questions with my
Well, the finalists are going to get That's the preliminary round. And then we have like
Oh, when we saw them,
That's how complicated. These people have some complicated.
I don't know. We have a dinner to go. Finalists in the evening.
you are one-man shop there by yourself. Yeah. Right. I went and rewrote the entire thing. And so I woke up to impressive.
I didn't think the line was that good in that final round. I thought yours was good. This was good.
Hi, can I have your attention, please? I just would like to say a little something before. If you could just find your seats. I would just like to make an announcement from our editors of this year's fact pattern. We would like to bring something to your attention that is actually very interesting about this year's issue. The issue in this year's Froessel competition of balancing free speech and reproductive freedoms is an appropriate one, given that this year marks the 40th anniversary of the Supreme Court's decision in Roe v. Wade. Justice Harry Blackmun's opinion in Roe cited 7 times to an article written by New York Law School professor Cyril Means Jr., who published the article in the New York Law Forum, the precursor to the school's law review. The year he was to have written this article, he was serving on a special commission charged with reviewing New York State's abortion laws, chaired by none other than New York Law School's own Honorable Charles W. Froessel, the man in whose honor we hold this competition today. Just a round of applause. And now for our judges.
Please be seated. We promised you a prompt decision, and we've delivered. This is part of our new rocket docket here. As we always do, we'll have some comments about the advocacy and advocacy that I think I can fairly summarize for my colleagues that we all thought was absolutely superb. I have done this competition, the finals of this competition, I think 7 years in a row now. You've been all very kind to invite me that frequently, and that you have not grown both bored and tired of me. I'm rather amazed, but it has given me some context to be able to hear and listen and judge. And this was a superb problem in all respects as it was written, and it was well argued by both sides. And we'll explain some of that as each of my colleagues make some comments. Should we announce the very difficult decision of the advocate who has prevailed first, or should we make our comments first?
I think we better do that first.
Yeah. Answered without even a pregnant pause. Yes. Well, then, rather than keeping everyone on the edge of her or his seat, we discussed each advocate and the performance of each advocate and the responsiveness and the coherence of the arguments and all that goes into an oral presentation before an appellate body. Everyone performed extraordinarily well. Each of you received very positive comments from everyone on this bench during our discussions. Difficult though the decision has been for us, I would announce that the prevailing advocate in this competition is Ms. Aruna Titiaka. Congratulations to you. Congratulations to all of you. Congratulations to me for being able to pronounce your last name. Anyway, we'll have each member of this court make some comments, and let me begin with Judge Amiri.
Oh, okay.
She is an experienced advocate in this area, so the real expert as opposed to me.
Thank you, and also on the other side of the podium from most of you as well. So I think absolutely all of you did a great job, and I know how hard it is to be on that side of the podium, and these are very tough facts as well. So just a few general comments and some feedback for each one specifically. Leopoldo, I thought you were very well prepared, and you knew the cases, you knew the record, and that was really to your credit, and so that was really fantastic. I think the only thing in terms of feedback to give you on the constructive end is that there were some parts I think that you were maybe a little too colloquial. And so just to kind of watch that, kind of get in the role and stay in the role and things like that. Aruna, I think you did a great job. Obviously, we chose you as the winner. And the only, I think you were clear and concise, and you handled all of us beautifully when there were 3 questions pending, and you. It's very hard to remember those questions and come back to them and stay poised doing that, and that was really fantastic. The only thing that I would suggest in terms of constructive feedback is that one of the hardest things to do at oral argument is making the best use of your time and getting to your point the fastest. And so there are just some places where you could have just nailed your point a little bit quicker because the time is just so valuable that you have up there. But that's my only feedback. Naveed, I thought that you were very comfortable up there. You were very calm. And I thought that you clearly knew the facts very well. My only feedback for you, I think, is that I think you got bogged down. I think substantively on this unwilling listener point and this chasing, and I think that was a hard place for you to be in. And so I think in terms of trying to figure out where your hard places are going to be and how you pivot out of them, and that's a skill in oral argument is if you have to say something that is not the best for your case, say it, but then pivot and get on to something that's better for you quickly. I'm sorry, it's Michael, right? Okay. I thought you were also very calm and very self-assured, and I think also substantively, just the one point for you is that you got bogged down on the distinction in Bartnicki that we kind of, at the appellate level, and particularly if this was actually the Supreme Court, that level of distinction, although I have seen Erwin Chemerinsky argue in front of the Supreme Court about the placement of a comma in a statute and what that means, usually you want to be thinking in terms of more broader principles of the cases and things like that, and not get into that very that really very specific factual distinction, which I think just got you bogged up a little bit. But I think everyone did a great job, and everyone seemed very comfortable and very poised up there, which is tremendous.
Agreed. Justice Soto.
I graduated from this law school in 1978, and I've been on the bench for 20 years now, and I'm so proud and privileged to be here and honored that you invited me to be at the final competition. All 4 of you were fantastic. Mr. Guerrero, you are great. Thank you. You're so passionate about your argument. We are actually felt the passion in your voice, and that was so important for us because we knew that you actually believed in what you were telling us. Aruna? Aruna. Oh, I love the way you said my name twice. That was so special, you know? And when you actually listened and heard what I was saying and remembered it and came back and answered me, oh, you just blew us away with that. You know, your ability to listen and respond and then to remember. And that's so important about actually listening and not just talking when you're making the arguments. Naveed, you did very, very well. I thought we were a little bit too hard on you, actually. And I told them...
I didn't. We're tougher.
I thought you were very good. You knew your cases, you knew your facts, and you really made a good presentation. And Michael, you have such a great voice and a great presence. I just kept looking at you and listening, and I understood everything you said. I think your contents were a little weak, but if you worked on it, you could be a master at this. You're natural. Thank you.
Thank you very much, Justice Soto. we were actually in various ways tough on all of you. This was what they call a hot bench. And at our ages, Joe, anytime anybody says we're hot in any way, I suppose, that's as good as it's going to get. But, I asked my colleague and friend, Judge Arenas, to go next.
Well, in light of the two comments we've already had, I mean, it's clear this was a well-prepared, able group. I listened to lots and lots of oral arguments. Unlike some district court judges which eliminate oral arguments, I have oral arguments on almost every motion. And so I hear lots of oral arguments, and this oral argument today compared favorably with almost any oral argument I hear on a weekly basis, because I hear arguments almost every week. The one point I do want to make is that when you get questions from a bench, they should be looked at as an opportunity. Sometimes the questions are, as my friend Judge Smith said, softballs. You can count the stitches on the balls coming in, but you ought to recognize that and use that opportunity to hit a home run. But even difficult questions are an opportunity. Questions that are difficult are an opportunity, and you should look at it that way. And so my one general comment for everybody is, when you're arguing a case and you get a question, whether an easy one or a hard one, look at it as an opportunity to score points. And but with that, I liked everybody's argument. I enjoyed today's proceedings immensely. And like Judge Smith, I thank you. Now, you've put up with me only 3 times recently, not 7. But I appreciate being asked back, and it's been a great privilege to be here.
You're very, very fortunate to have a very committed and passionate advisor, Professor Abraham. I've now had a chance to work with her, and my work on this program over the years when I've come in for argument, the finals, and I know the amount of effort she puts into this annual competition and her commitment to all of you, and I know what a great advisor she is for all of you. So, Professore.
Thank you, Judge. I just want to start by saying thank you to all of you judges. I mean, you've really brought so much wisdom, experience, and sense of humor and preparation, and it's just so valuable to the students. As moot court advisor, yes, let's give them a round of applause. And coming in on a Sunday afternoon, some of whom come from far away and some from close, it's giving up a lot of personal time that they're willing to give to you, and it's really an unbelievable treat. For you to have that opportunity to argue in front of these judges is just amazing. And now, as my as faculty advisor, I just want to say I'm overwhelmed by you guys. I'm thrilled to have you on the team. As you know, the judges said, this was an unbelievable round. All 4 of you have incredible talent. And, you know, in any other competition, any one of the 4 of you could have won. You were really all so well prepared, and I am really so happy to see what I just saw today. Preparation, mastery of the facts, mastery of the law, deference to the court, poise, great presentation style. It's really great for us to be starting here as, you know, new members of the moot court team, and moving forward from here. It's really exciting for all of us. I know for Alex and Alona, who have, you know, written the fact pattern and the bench brief, to see it come alive with these incredible advocates must be an incredible experience, and I just want to give them a round of applause for everybody else on the e-board, and for Catherine and Ariel, who have organized the whole competition, and for our great editors. I mean, everybody's done a great job. A couple of really, really quick comments. I see that you're getting the idea of oral argument, that obviously using the judge's questions as an opportunity and not running from them is key to being a really effective oral arguer. And to remember that it's a conversation with the judges and not not a war or not a competition with the judges. You're on their side, they're on your side. And so when you get a question, to answer it for them as clearly as you can is really the goal, not to try to avoid the question. And sometimes with the hard questions, it's harder. And that's why practicing the hard questions is what we do in the moot. So sometimes you get a question where they're really trying to help you, and I know it's really hard. But to just kind of stand back and relax and say, thank you, Judge, that is exactly what I was trying to say, and then go on from there is a good thing. And, you know, to sort of remember it's a respectful conversation that you're having with the court, and not to be afraid that assume what they're saying is poking holes in your argument, because sometimes it is, but sometimes it isn't, and they're really helping you. And you can learn a lot by really recognizing when they seem to maybe be on your side a little bit. And the other thing is keeping it brief. When you get to your conclusion, you've made your best points, it's at the end, don't go on and on. Because judges have a lot of cases, they really appreciate when you come to the point, and at the end, just stop if you've made your point, and don't add things unnecessarily, even if your time isn't up. And most of you did that most of the time. It's just really important to remember. But I really want to congratulate all of you. I am so pleased. It's been a great argument.
It really has, and it is not uncommon for judges who do moot courts to, in the course of being polite and reinforcing, to perhaps exaggerate a bit. I can truly say that is not the case here. I do a number of moot courts each year. As I said, I've been up here now. I think this is the 7th year, and you were absolutely superb. It's been a delight, starting with reading the problem and seeing what an interesting problem it was, through watching each of you, the 4 of you, advocate your respective positions. I have nothing to add. The other members of this court have certainly covered everything far better than I could. And unfortunately, I'm going to have to run. I have a plane to catch in a while, which means I'm going to miss the dinner. One thing you'll find out with federal judges is they almost never pass up a free dinner, and in my case, never a free drink. I can assure you of that. So, you know, it is a real sacrifice on my part to have to duck out at this point. But you've, as Judge Professor Abraham has said, listen to the questions at oral argument. Answer the questions directly. Regard oral argument in and of itself as an opportunity. On most courts, not here in the Second Circuit, where they hear oral argument on everything. With most courts of appeals, it's discretionary. My court hears oral argument in only about 25% of the counsel cases. So when you've been given oral argument, it's an opportunity. The judges want to hear something from you, which is all the more reason to listen to what the questions are and respond to the questions you've been asked, because they are focusing on something sometimes that isn't what you're focusing on. So it's important that you listen and use that time, which is usually just 15 minutes aside on our court, as economically and as effectively as possible, being responsive to what the judges want to hear from you. I think these advocates did that and did it well today. One, if I may, just as an aside, Alona, I hope I'll have an opportunity to talk with you sometime. I understand that you are from Kosovo, and I have made 3 visits to post-war Kosovo, to Pristina, but where I worked at with the University of Pristina, but I've been up to the bridge at Mitrovica and all over what was then the province, essentially, before independence. And I hope someday I'll have an opportunity, if not at a dinner here, to discuss your homeland with you. Thank you all very much, or not, as the case may be. But, all right. Thank you all very much, and with that, we will be adjourned.